writing, the shortest time it takes is a month. That is one document. If we have 3.4 million signatures that we received, would it be possible to give that sort of a meaning to that article? I rest it at that, my lords and my lady. I see my time is quickly running. Permit me to go to the second area of my presentation, which is in relation to the question of a separate registration of voters for purposes of a referendum. My lords and my ladies.
Sorry, I don't know that you're moving away from the area of verification.
Yes, I'm moving to the next thing.
From reading of the judgment,
yes,
it seems like the case for the IBC was that because there wasn't a legal framework for verification under Article 272, the Article 257.4.
Yes, my lord.
Then the IBC fashioned some administrative procedures.
Yes, my lord.
And your argument before the Superior Court was that those administrative procedures met the threshold of the Constitution.
Yes, my lord.
And we must recall what Senior Counsel Oraro submitted yesterday, that the provisions in respect to the referendum are in fact more exciting than that of a presidential election. Now, please comment, assuming that the administrative procedures in fact made constitutional muster.
Yes, my lord.
Do comment on paragraphs 761 and 762 of the judgment, and just let me read it because it's short. In addition, even if the administrative procedures had been valid, it is clear that the IBC did not comply with them. For instance, IBC published the list in the website on Thursday, 21st January 2021. Members of the public had up to Monday, 25th January 2021 to read the list and raise any issues. The judges then say that the administrative procedures provided for a 2-week period so that the registered voters could verify or make comments, but IBC only gave 5 days, including the weekend. First, is that a finding of the court factually accurate, that the period was shortened from 2-week period to 5 days?
My lord, thank you very much for that question. Two things that I want to say about that. One is that my learned friend, Mr. Kipkoge, will be addressing you after me in great detail about the legislative framework, the legal framework. But in relation to the specific question that you asked, that is on paragraph 761, one of the issues that we'll be addressing you on is that the administrative processes have been mischaracterized. They've been mischaracterized and elevated to a position where they would fall to be under the Statutory Instruments Act, which they are not. These are internal procedures. Why do we say the internal procedures? My lords and my ladies, when we, for instance, say that please delete the name of somebody who does not have an ID, it is because of the reading of the fact that that person is not a voter in relation to Form A, which had given. So that is why we relate it, and we say you don't need a law to tell you that once the Elections Act has defined a registered voter is somebody who has given you their ID number, then you don't get the ID number. You don't need another legislation to come and tell you, please now remove the legislation, because it fits under the rubric of Article 257.4 that a registered voter must be that person who has given those details. So the moment you fail to give any of those details, then you don't fit into that space. So it will be our case, and Mr. Kipkoge will be addressing you on that later, that if we had understood those administrative processes to be internal processes, then we would not then create the obligation that the learned judges created about them. To answer the second part of the question in relation to the shortening of the period, my lords and my ladies, there is need to create some flexibility to the institutions that we have. We have the commission receiving or sending out a notice that we will be happy to receive a complaint from any Kenyan who would say that their name was not included in this, or rather, their name was included without their consent. My lord and my ladies, after 5 days, you've not received any. Must you wait for the 14 days? And I want to look at the converse of this. If we had gotten, my lords and my ladies, to a period of those 14 days, and names are still coming in, my lords and my ladies, will we say, no, ours is 14 days, anything that comes after this does not matter to us?
I asked the question because if you look at the framework on verification of the voter register,
yes,
it has a window which is known to all Kenyans and gives them sufficient time to do that. And I'm not saying that the procedures of the administrative procedures of IEBC are subsidiary legislation, but if having, and the IEBC has the experience of conducting referendum and election and the competence. They thought about it, they said 14 weeks is a fair period. But then in their wisdom, they then choose to reduce the period to 5 days. That was...
Yes, my lord, and perhaps so that then we just look at it in proper context, even on that question, it would be equivalent to comparing two things that do not exactly fall for comparison for this reason. When we are looking at giving time to Kenyans out there to come and verify their details, say for a period of 30 days under the Elections Act, it is a statutory provision under Section 6 and 6A. What do those do, and why does it happen that way? It is because the register is our document as the IEBC. Once you've given us, you made the application and given us your details, we tell you, okay, now we've captured your details, but before we get to the elections, before we get to a referendum, please take time to go and verify your details from our document. The flip side or the difference would be the promoter is the person bringing you their document, saying this is our document. My lords and my ladies, I think there is a bit of a difference in relation to that question. My lords and my ladies, I'm seeing time is running quite a bit. Permit me to talk about the question of separate registration of voters for purposes of the referendum. My lords and my ladies, we draw your attention to paragraph 769 of a judgment of a superior court. If you permit me, I could very quickly read through it. That say, we begin by noting that every single day, citizens attain the voting age. These new citizens have a right to be registered as voters and to participate in the proposed referendum. There was no evidence placed before this court that the IEBC has been discharging this constitutional and statutory obligation to enable the citizens who have attained the voting age to register as voters. The IEBC also stated that the last time the voter register was revised, and I repeat, was revised, was just before the Kibra by-elections. This was a confirmation that it was not discharging its constitutional and statutory mandate to continuously register voters and review the register of voters. Because of that analogy, they then, at paragraph 9 of the declarations that they make, say that a declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration exercise. My lords and my ladies, permit me to also relate that to the submissions made by the respondents, both in the court below and this court. I would want to again pick on the submissions filed by Mr. Morara Omoke, the 76th petitioner. Mr. Morara Omoke, in the submissions filed before you, at paragraph 117, says, we invite this honorable court to take judicial notice of the fact that the predominantly youthful dynamic of the Kenyan population is such that hundreds of thousands of citizens become eligible to be registered as voters every year. Since it is common ground that the IEBC last updated, again underline, last updated the register of voters between February 2017 and March 2017, the 76th respondents' apprehension apprehension about the disenfranchisement of billions of voters in the intended referendum is well-founded. My lords and my ladies, what do I have to say about this? I say that both the learned judges of a superior court as well as the respondents misconstrued the meaning of the various words that are used interchangeably within the electoral platform. Example, when the learned judges say that the register of voters was last revised in relation to the Kibra by-elections, what exactly, why do we say they were wrong? We say they were wrong because the context in which they are using the word revised is to mean continuous registration of voters, and which they then say that the IBC has failed on. My lords and my ladies, the word revised used in the electoral sense has a specific meaning. To this, my lords and my lady, look at Section 5 of the Elections Act. My lords and my ladies, Section 5 of the Elections Act, almost in similar terms, provides for the regular and continuous registration of voters. It then provides for exceptions. The exceptions being that where you have a by-election, then the registration in relation to that, say, either county assembly ward or constituency will be stopped for a moment to facilitate that election. How does it facilitate that election? That at that point you close the register and again allow Section 6 and 6A to fall into play, so that the people who will be voting in relation to that area can come in to correct their details ahead of that particular exercise. The same thing goes for when you have a general election. The same thing goes under the exception at 5C for a referendum. That is not C, but BA. It's numbered as BA. So the word revised then, as used in that context, is for purposes of enabling Section 6 and 6A to kick in. And so when the learned judges of the Superior Court asked the question, and it was a question that came from the court because it wasn't an issue, Kibra came in as an example. That when did you last, at that point in time, the last by-election that had just been held were the by-elections in Kibra. And so then learned counsel then appearing for the IBC made the explanation that the last time we revised the register of voters was in relation to the elections in Kibra. So that is not to mean and should not be equivalent to saying that there was no continuous registration of voters. My lords and my ladies, again, the same mistake. It's a mistake again of terminology is used by Mr. Morara Omoke when he says it is common ground that the register of voters was last updated. The updating that we're talking about here is different. And my lords and my ladies, I would invite the court to look at the provisions of Article 88.4a, 88.4b. 88.4a, my lords and my ladies, if I could very quickly just so that we understand the distinction between these two processes, reads that the Commission is responsible for, among other things, the continuous registration of voters, and B, the regular revision of the voters' roll. Continuous registration of voters carries on, and my lords and my ladies, the IBC has 290 offices throughout the country which conduct this continuous registration of voters. Revision of the roll, on the other hand, is once you've mined details or data from the applicants who want to be enrolled as registered voters, you then periodically take that data and upload it to have the register of voters. That is a continuous process. My lords and my ladies, the question that I would want to ask now that I'm there, why do we, in resolving that question, start by asking, why do the learned judges of a superior court start by asking for evidence from the IEBC? If the case was a case that was presented by the petitioners, the first port of call, my lords and my ladies, as we know it, is he who alleges must prove. There was an obligation on the part of the petitioners in the lower court to then discharge that burden. My lords and my ladies, you'll have a moment to look at the record. There wasn't a single drop of evidence that was given in relation to the fact of there being no continuous registration of voters.
And what did the IBC say about that issue?
The question about registration of voters?
Yes.
My lords and my ladies, we have the replying affidavit of one Michael Goa, where Michael Goa states categorically that the registration of voters has been a continuous and ongoing process.
Thank you. Let me just understand. Whenever we have an election,
yes, ma'am,
beyond the continuous voter registration, which you say IEBC has been conducting,
yes,
with an election looming, is there something more that your client does in preparation for the election?
Yes, my lord. Permit me to address you on that.
Yes, and I imagine that is that they actually carry out a nationwide voter registration, is that correct?
Not quite.
What do they do?
Continuous voter registration carries on. What
Yes.
they do is, again, to use their internal flexibility. They say, we need to now go out and encourage Kenyans to vote, or rather to register for purposes of election. That is what has been dubbed mass registration of voters.
Exactly, thank you, mass registration of voters.
Yes, madam.
And that is to ensure
Yes.
that when the people vote,
Yes.
you can have as much a representation of the people,
Yes.
registered voters as possible.
Yes, madam.
Would that wise approach also be one that the IBC would do with regard to an important question like a referendum on the Constitution?
Oh, yes, my lord. That's true. The only thing that we then need to ask ourselves is, at what point does the IBC make that decision? We say that decision, my lord, can only come when the IBC is seized of the referendum. As we speak, the IBC is not seized of any referendum.
Thank you. So now, if you look at the declaration that you have a problem with, what did he say about that, about registration?
A declaration is hereby made that the Constitution of Kenya amendment...
What page, sorry, what page of the...
That is, I think, at page 312, that's the last declaration, number 9. A declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration exercise.
Is that the same as mass, the mass thing you're talking about?
Not quite. Nationwide, it's always an ongoing process, because even now there's a nationwide registration of voters.
So do you have a problem with that declaration as it stands, that before you can have the referendum, because they're saying before the referendum,
yes,
before you can have the referendum, there should be a nationwide voter registration. Is that a problem?
Yes, my lord. It is a problem in this sense. It first presupposes, because it comes from a concern that was raised by the petitioners, that there is no voter registration going on. And my lord, it's not just about registration.
But if you actually are doing it, it means they are declaring that which is already happening. Why do you have a quarrel?
My lord, perhaps context is also important for this. Before the IEBC engages in any of these activities, what do? They get data from other institutions. National Registration Bureau, they ask them, how many people have you registered, for instance, in the last 6 months? So on account of those sort of statistics, they make informed decisions that, oh, we think that there's been maybe about 500,000 more Kenyans that have been registered. Let's have a drive. Let's encourage. The more important question, though, is why don't we let the IBC be the ones to make that decision? Why do we want to look like we're getting into their position and telling them, we know you IBC, you may not register us after all. We want to have an order just in case. Why can't we allow them to do? In any case, my lord, when properly seized of the referendum, when the opportunity eventually comes, the IBC will look at this data and they'll say, we think perhaps it will be their decision. I'm not preempting that we now need to run mass voter registration. All that I'm saying is we need to give them that flexibility to make it their decision because of their independence. Thanks, my lord.
So Mr. Gumbo, what I was asking is this. Because you referred us to paragraph 769,
yes,
where the learned judges say that IBC was not discharged its constitutional and statutory obligation to enable citizens, to do continual registration. You referred us to the paragraph 117 of Mr. Morara Omoke.
Yes, my lord.
Now, to enable the court reach an informed conclusion or finding as to whether the learned judges were right in the words they put in page 769. Can you please show me or show us the affidavit of Michael Goa where you said the contrary, so that we are able to place it in its context?
My Lords, this is volume 5 of the record of appeal.
So we will find it at volume
5, page 2193.
2193.
At paragraph 10.
So that answers, in your view, the issue raised by the learned judges at paragraph 767, 769.
Yes, my Lord.
Thank you.
Thank you very much, my Lord. And more importantly, my Lord, like I said, before the learned judges pose that question, the primary obligation on the part of the petitioners would have been to discharge that burden. My Lords, we would be looking at a situation where somebody says, and this I think is what learned senior counsel Professor Guido Mugai was alluding to, we would want a situation where somebody says, I am a Kenyan. I approached the IEBC to register as a voter and I was denied that opportunity, or that there was a potential threat of me being denied that opportunity. Okay. In the absence of that, my Lord, we cannot rely on what Mr. Morara Omoke says. He is apprehensive. An apprehension, my Lords and my ladies, is not evidence. My Lords and my ladies, perhaps
are you watching your time?
Yes, my Lord, but I'm also praying that for the interventions, my Lords and my ladies, perhaps there's equal attention to the time that runs off our plate.
Yeah, just before you move on.
Yes.
Now, you have said the onus was on Mr. Omarara to prove
yes.
the allegation. And at the same time, you are telling us this is specialized information that your client insists of. Don't you think that the farthest Mr. Omarara could go is to raise that issue? And then what for your client is simply to come forward and say, yes, you have raised this. As a Kenyan citizen, you are entitled to it. And here is what I have. What you are asking for is already in place. And I think that is what the judges were interrogating at the paragraph 769, what the President has brought to your attention.
Yes, my lady.
Yeah.
May I respond?
Please do.
So, my lady, it is okay to make such an inquiry, but must such an inquiry be made for the first instance in a court? That is the concern. Why don't you, as a responsible Kenyan, come in and say, wait, we think we may be running into an election. What are you people doing about this election? Is there a continuous registration of voters? Please get me a document to see that there's continuous registration of voters or there's none. It is not, in our view, okay to make a first port call, which reminds me of what I learned in the laws about injunction, something called queer timet injunction. You just say, Timeo, I fear. My Lord, I think there is a greater obligation. There is a greater obligation on anybody who wants to confirm, and that, my Lord, again, is information that is available out there. Every so often, and perhaps I'll just make reference to the affidavit of Michael Goa, again, filed on the 25th of June, 2021, at paragraph, that is, at paragraph 6, that's my lady, attaching a gazette notice. My lords and my ladies, that gazette notice does one thing. Every so often, the Independent Electoral and Boundaries Commission, as a way of communicating to Kenyans, says that we have up to now gotten this number of registered voters. We have shared one of those gazette notices, so that then it is just confirmed, because it is a legal provision that it is that, my lords and my ladies, there is continuous registration of voters. My lords and my ladies, perhaps I would move then to the next part of my presentation on the question of public participation. Sorry, my lord. Thank you very much, my lord. So on the question of public participation, specifically as to whether there is an obligation on the IEBC under Article 2574 to confirm that a promoter...
Mr. Goa, please permit me. I'm so sorry about this.
Yes.
You made reference to this Gazette notice.
Yes.
Which is attached to Mr. Goa's affidavit.
Yes, madam.
I just confirm that this is Gazette notice number 2934 of 16 September 2020.
Yes.
Right?
Yes, my lord.
Now look at it.
Yes, my lord.
It says you are certifying the completion of the revision of the register of voters as at what date?
This is as at 31st December 2019.
2019.
Yes, madam.
This is something that Mr. Goa filed here before us 2 days ago. Am I right?
Yes.
So you get an opportunity to indicate what you're doing with regard to continuous nationwide registration, and what you brought before us is an indication of registration as at 31st December 2019.
Yes, my lord.
Okay.
And permit me to explain why.
No, I just confirmed the date.
Yes, my lord, but
Okay.
it is important that I contextualize it.
All right.
The obligation, my lords and my ladies, that is done periodically. So that, again, towards the end of this year, there'll be a similar Gazette notice issued. It doesn't mean that there's no registration going on. It's only that it can't be issued weekly. You issue it maybe after 6 months, you issue it after 1 year.
Was there one indicating registration as at the end of 2020?
My lords, I maybe would want to just confirm that from the clients.
All right, thank you.
Yes, but my lord, the position, as I indicated, what was the evidence that was presented by the other side? Why do we want to shift the burden to say we allege, prove? We must start from somewhere for sure.
Thank you.
Most obliged, my lord. Then on the question of public participation, we look at paragraph 577. The learned judges of the Superior Court say that additionally, the IEBC was under an obligation to ensure that the BBI Steering Committee had complied with the requirements of public participation before determining it had met the constitutional requirements for transmittal to the county assemblies. What do we have to say about this, my lords and my ladies? Simple. Article 257(4) reads, shall verify that the initiative is supported by at least 1 million registered voters. Where do we get this obligation and impose it on the IEBC from that article? My lords and my ladies, I have tried to interrogate the submissions that have been presented, even by the respondents, on that question of public participation. The closest I've come to is submissions filed by a learned friend, Mr. Harvey, which says that that obligation is to be found in the writings of John Locke, Baron de Montesquieu, and Professor Ben Nabweze. This is found at paragraphs 36 and 38 of the submissions that have been filed. My lords and my ladies, I want to pose the question. Would it be open for the IEBC to reject a bill together with more than 1 million signatures presented on the question of public participation? Would they object without attracting or fomenting a cause of action against them as imposing a condition that the Constitution does not contemplate? My lords and my ladies, it should not be taken that the IEBC does not appreciate public participation. The question of public participation is so important under the heart of IEBC. The only thing that we are saying is that that public participation must be context specific. In relation to Article 257(4), my lords and my ladies, that obligation does not lie with the IEBC. We've seen, if we read the entire spectrum of Article 257, we have obligations to the county assemblies, the parliament, and the grand extravaganza itself if we ever get to the referendum. That is the ultimate public participation. IEBC would be ill-equipped to get to a point of saying, that we are rejecting your initiative because you've not given us minutes of meetings that you had or any other demonstration of public participation, because the Constitution at that point in time does not impose the obligation on them. To the flip side, my lords and my ladies, that would be a very good ground for somebody to raise if at the end of the day or at the end of this process, somebody files an application under Section 80 to 88 of the Elections Act to file a referendum petition where somebody will be challenging the fact of there not having been sufficient public participation.
The learned judges were saying that IEBC was interpreting and applying the Constitution.
Yes, madam.
And therefore, the values espoused under Article 10 kicked in. What do you have to say about that?
Yes, my lord, they kick in. But at what point, who has the tools to measure that? At that point in time, the requirement for purposes of confirming public participation is a requirement that if you read, and this is about holistic reading of the Constitution again, if that obligation to make that confirmation that there was public participation is reposed expressly in another institution, then it would be inappropriate for IEBC to tell somebody that before you come to me, present me with three things. Get me a bill, get me 1 million registered voters, and also get me evidence that you had public participation. My lords and my ladies, that is stretching the meaning of the text of Article 257(4).
And I think we really had many interventions. But I understood, and maybe you could comment on this, I understood Senior Counsel Kambuni to say that in fact, at the point when someone, and I don't want to use the word initiator, which you have a problem with, someone initiates the process under 257(1) and collecting the 1 million votes, there is no need for public participation. That in fact, you can look for people who share the same view, friendly people, as long as you get the 1 million votes. And that the issue of public participation is at the point the bill is then presented to the county assemblies. So, I mean, you could connect that. I don't know whether you have a comment.
Yes, Article 257(1) is the one that then introduces that threshold. And my lords, the obligation under Article 257(1) is reposed in the promoters, so that if today we sat with your lordships, ladyships, as members of the legal fraternity, we say that we have looked at this Constitution and we've specifically looked at Article 163(3)(a), the jurisdiction of the Supreme Court to make a determination on a presidential petition. And we think these 14 days are too short for that court to do that, to do justice to that matter. We need to expand or get that period expanded. What does that mean? It is a well-founded proposal. What does the Constitution expect? We may sit here, we may be 100 people. If you go to the IEBC today, you tell them this proposal makes sense. You say, all right, it might make sense to you, but because this Constitution is a document that is shared by Kenyans, can we get at least 1 million of you who think the same way so that we can engage Kenyans? So essentially, it's more of a trigger. So that you say, we've gotten 1 million people who think that there's need to expand for the 14 days, please consider them. Then the other Kenyans will be asked, oh, there's a proposal to expand this period. We then open it up to a debate. We say the reason why we think there's need for this proposal, or rather for this amendment, is so that the court can have perhaps 30 days, so that there's not too much pressure on the court. It will now be upon the actors in that space, the various actors, to engage in public participation at that point in time. That is my understanding of that provision, my lord. My lord, my ladies, perhaps I would quickly then run to the last question about the referendum question. On this issue, my lords and my lady, paragraph 611 of the judgment, the learned judges of the Superior Court say, we have been asked to determine whether Article 257(10), requires all the specific required amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot. My lords and my ladies, the learned judges of the Superior Court then go on to make a finding, that is Declaration 18, that a declaration is hereby made that Article 257.10 of the Constitution requires all specific proposed amendments of the Constitution to be submitted as separate and distinct referendum questions to the people. My lords and my ladies, why do we, as the IEBC in particular, why are we aggrieved with that finding? One, I would want to ask the question, the learned judges of the Superior Court, they were invited. First principles, whenever you're invited to make a determination, you ask yourself, and this is the point that learned senior counsel Professor Gideon Mugai was making, you must ask yourself whether you have the jurisdiction to make that determination. It is not just a question of saying a question was presented to us. Satisfy yourself. My lords and my ladies, we say that because in the absence of a controversy, you present such a question to the IEBC, then you are at best inviting them to exercise advisory jurisdiction, which they do not have. I then ask myself the question related to that. What was the controversy that was presented for the determination of the learned judges? My lords and my ladies, at the second paragraph after the learned judges, I think paragraph 612, the learned judges find a report. They say that the petitioners cited the final report of the Independent Commission on Referendums on this question from the University College of London. My lords and my ladies, how is this report to form a controversy that is being discussed in a court of law in Kenya? Let me leave that at that and say, my lords and my ladies, Section 49 of the Elections Act reposes the obligation to make a determination on a question touching on the referendum on the IEBC. In particular, 49.2 says, where an issue to be decided in a referendum has been referred to the commissioner under subsection 1, the commission shall frame the question or questions to be determined during the referendum. Now, with that as a background, I submitted earlier, the IEBC is yet to be seized of this referendum. They can only and will only be seized of this referendum if under Article 256(5)(a), His Excellency the President sends or triggers that jurisdiction. So before that arises, it is then our humble submission that it is premature to expect the IEBC to have engaged in that question. My lords and my ladies, it is our submission that that issue was not ripe for determination before the learned judges of the Superior Court. My lords and my ladies, again, it is important to note, and this is a point that learned senior counsel Professor Gideon made very well, the IEBC is an independent institution. They cannot be, and we cannot have a situation where what they're supposed to be doing is being discussed away from them and a direction given to them that you shall, at the point of dealing with the referendum question, do A, B, C, and D. My lords and my ladies, this, in our view, is an inappropriate application of the Constitution. And my lords and my ladies, I am not alone in saying that. A member of, a honorable member of the bench, Justice Fred Ochieng, in a case that we've referred to time and again throughout this decision, that is a decision in Titus Alila, and it's cited as one of the authorities that appears at page 230 of our bundle and digest of authorities, when faced with a similar question on the issue of referendum, had the following to say. At paragraph 57, Justice Ochieng says, Section 49 of the Elections Act gives to the IEBC the mandate to frame the question or questions to be determined through a referendum. At paragraph 59, the learned judge says, this court cannot purport to give the IEBC directions on exactly how to carry out its responsibility in that respect. The last paragraph, in a bold statement, it says, if the court were to give generalized directions to the IEBC when it had not been shown that the commission had started from a path not established by law, that would constitute a blatant interference by the judiciary in the constitutional mandate of an independent commission. My lords and my ladies, that decision was presented before the learned judges of the Superior Court. We have seen the declaration that they made. We leave it to you, my lords and my ladies, to make a determination. On my feet, my lords and my lady, I would want to make a plea that on that question, and it reminds me or takes me back to the to the question that Justice Gatemu Kairu asked. When faced with such a situation, would it not be right to have a setting where there is a harmonious way of facilitating institutions to work with what I would call clear directions from courts in terms of court judgments? My lords and my ladies, what am I saying? I'm saying it places independent institutions in very awkward positions when today there is a judgment that could come from Judge X in a place Y. Tomorrow, another decision touching on the same issue, constitutional interpretation, again from another judge. It leads to a situation where we will be forum shopping. My lords and my ladies, that is not the sort of practice that we want. In fact, as a practitioner of law, my lords and my ladies, I've been put in a place where sometimes it is difficult to even advise a client. You advise, you give a written opinion, but you must timestamp it. Why? Because if you don't timestamp it and issue a disclaimer that my opinion is valid up to the time I'm signing this decision, another contrary decision will come from somewhere. And my lords and my ladies, you'd be accused of having misled an institution. Our proposal, my lords and my ladies, is that when dealing with these sort of issues, particularly interpretation of a question of public law, it could be a constitutional interpretation. My lords, my ladies, you may want to give guidance in how then the court below you, the learned judges of the Superior Court, can apply or exercise their jurisdiction without creating hardship to the institutions that depend on them for guidance and interpretation. An example would be the Lady Justice Okwanyi says that IBC, you have jurisdiction. Please you have quorum, carry on with what you're doing. So they then go on to make arrangements, do this, do the other in relation to their institution. Shortly thereafter, they told, wait a minute, whatever you did in the hope that you had jurisdiction is actually null and void. What does that do to institutions that then are expected to apply the law? It then places them in a position where the man in Kangemi bus would start doubting the ability of these institutions to work the way they should work. So it is a really important question to ask. Let us have, my lords and my ladies, a Titus Alela moment. Let's have a guidance on this very pertinent issue. My lords and my ladies, with that, I think I'm only left with 15 minutes. Permit me to allow my learned friend, Mr. Moses Kipkogei, to address you on the other matters. I'm most obliged for your patience.
Thank you. Mr. Kipkogei, it looks like you have only 15 minutes.
My lord and my ladies.
Just state your name for the record, and you may want to lift up, to raise the microphone.
My name is Moses Kipkogei. I join Attorney General Emeritus, Professor Muigai, and Mr. Gumbo in appearing for the IEBC. I will try my best in the remaining time.
Are you able to adjust the microphone so that it is kind of, yes.
It's an issue to do with height, my lord. I should perhaps have had a longer podium. My lord, I will address my lord on 3 elements which arise from the decision of the Superior Court in relation to the declaratory reliefs which were granted by the court. And that relates, my Lord, to declaration number 11, declaration number 12, and declaration number 17, which are contained at pages 7167 and 7168 of our bundle of our record of appeal. My Lord, those three declarations relate to the legal regime applicable for purposes of conducting a referendum and the finding in relation to the administrative guidelines which were issued by the IEBC to govern the process. I note, my Lord, that Malanet seniors who've addressed you ahead of me have touched on those, and I will try to touch on areas which they did not touch on. But before I do so, my Lord, allow me to address you on just one aspect which arose from Mr. Gumbo's submissions in relation to the interpretation to be accorded to Article 257, sub-Article 4. My Lord, the learned judges of the Superior Court expended quite some considerable effort in unpacking the phrase verification of signatures. My Lord, that phrase does not exist anywhere in the Constitution. What is in the Constitution, my Lord, is a phrase which reads as follows: verification, quote unquote, verification that the initiative is supported, and it continues. And it ends with voters. That was important, my Lord, to highlight because it is direct, it directly affects the process which was put in place by the IEBC, including the administrative guidelines which were published, which were issued by the Commission. My Lord, declaration number 11, my Lord, in that declaration, the Superior Court states as follows, that a declaration is made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. They repeat in somewhat similar language in declaration number 12. My Lord, allow me to address you on the last sentence or the last phrase of that declaration, nor a legal framework to govern the conduct of a referendum. My Lord, the Elections Act, in its long title, states as follows, that it's an act of Parliament to provide for the conduct of elections to the office of the President, the National Assembly, the Senate, the County Governor, the County Assembly, and to provide for the conduct of referenda. My Lord, we submit that the declaration by the Superior Court that there was no law governing the conduct of referenda was erroneous and without basis, because there is an act of Parliament which declares itself in its long title that it governs referenda, and it is the Elections Act. When you go through the Elections Act, my Lord, you will note that in relation to the Register of Voters, the Register of Voters applies to both elections to elective positions, and referenda. In relation to accreditation of observers, Section 40, it applies, my lord. There is a whole part 5 of the Elections Act, which is dedicated to referenda. There is a whole chapter dedicated to dispute resolution for referendum processes, running from Section 88, my lord, to Section 103 of the Elections Act. The Electoral Code of Conduct, which is a schedule to the Elections Act, applies not only to elections, but also to referenda. The word referendum has been used in the Elections Act 167 times. My lord, Election Offences Act applies not only to elections, but also to offences committed in the course of referenda. The Election Campaign Financing Act, my lord, also applies to referenda. How then did we end up with a finding by the Superior Court that there is no law governing the conduct of referenda in Kenya? My lord, that was an erroneous finding, and we will be asking you to set aside that declaration without much ado. My lord, if you look at the election general regulations on the conduct of elections, they apply to referenda as well, including the statutory forms, which are an annex to the elections general regulations. In fact, one of the forms, my lord, is a sample ballot paper for the referendum, Form 30, which is provided for in the elections general regulations. My lord, when you look at the elections registration of voters regulations, you will find statutory forms, like for instance, Form J, which is a form for registration of voters in the diaspora. That particular form applies to voters who wish to vote in the diaspora and contains an express limitation that those voters who wish to participate are only limited to participate in referenda and presidential elections. My lord, consequently, it is an erroneous finding to make that there is, that there is no law governing referendum processes. It would have, perhaps the court would have limited its findings to collection, presentation, and verification of signatures. But they went ahead to say that there is no law with legal framework governing the conduct of referendum. My lord, I want on those three elements, collection of endorsement signatures, presentation and verification of signatures, my lord, to associate myself with submissions of counsel who have submitted ahead of me and submit, my lord, that Article 257, subarticle 4 is self-executing in that regard. It says what it says. It permits no laborious interpretation. It directs promoters of the initiative to submit the bill with the accompanying signatures to the commission, and the commission shall verify that that initiative, it is the initiative which is being verified, is supported by 1 million registered voters. There is no requirement for a forensic analysis of signatures. It is a confirmation that the persons who are said to support the initiative do support the initiative. And it takes many forms, my lord, and we've elaborated in our submissions the mechanisms which are available and which have been tested worldwide for the verification of signatures to support an initiative. It is not, as Mr. Gumba has put it, a process where investigators have to be called in to check whether the signature belongs to that particular person in the sense of an investigation under like a criminal investigation. My Lord, allow me to spare my remaining 5 minutes to address you on the administrative procedures which were published by the Commission. My Lord, under Regulation 100 of the Elections General Regulations, the Commission has been donated power by Parliament to publish guidelines in the Gazette. And when the Commission is minded, as an EMD, to publish guidelines, they do so. With respect to the guidelines which are alluded to in the judgment of the Superior Court, the Commission did not publish. It was not because for want of power or lapse in its processes that they did not publish. It was deliberate, because they are internal rules. They are meant for use by its staff. You will have occasion, my Lord, I do not have time to take you through those regulations, but you will notice, my Lord, that it is in the nature of a standard operating procedure issued by commissioners to its secretariat. How it landed in this court and became a subject of challenge, my Lord, is, you will notice from the record, my Lord, that a request was made by the 82nd respondent, Muhuri. And they asked, do you have any guidelines which you use to verify signatures? And there was a response from the Commission. Yeah, oh yes, we have regulations, we have guidelines, our internal guidelines. They took those guidelines, together with a letter from the Acting Commission Secretary of the IEBC, and challenged it in court. That is how those guidelines have landed before you. But otherwise, they would have been at anniversary towers, not subject of challenge. They are internal to the Commission. They are manuals, internal manuals for the Commission, standard operating procedures. They have not acquired and were never intended to acquire the status of a statutory instrument within the meaning of the Statutory Instruments Act or Cap 2, Interpretation and General Provisions Act, and consequently, they should not have attracted the order which was, the declaration which was issued under Declaration number 17 of the Superior Court's declaratory reliefs. And consequently, my Lord, we will ask you to set aside those declarations. My Lord, allow me to spare the last minute to clarify one issue which was addressed by Attorney General Emeritus with respect to the existence of unamendable clauses and whether the High Court made a finding to that effect. I'll just refer you to the appropriate paragraph in the judgment of the Superior Court. At paragraph 681F, where the court states in no uncertain terms that amendments to Article 89 are unamendable. You, my Lord, Justice Kiage had posed a question to Attorney General Emeritus whether the Superior Court made such a finding. My Lord, that finding does exist, where the Superior Court stated that amendments to Article 89 are unamendable. That would be all, my Lord. I will donate the last 30 seconds to the court. We ask you... I will ask my lords to allow our appeal, set aside the judgment of the Superior Court.
Thank you for your generosity, Counsel.
Thank you, my Lord.
Thank you. Now, on that happy note of a donation of time to the court, we have, I think, one appellant remaining only. Is that so, Senior Counsel Mr. Wetonyi?
Yes.
And you said you would take 1 hour because you donated 1 hour.
Just 1 hour, perhaps with a bit of concession from the court, a few more minutes.
So you have like 25 or 20, about 20 minutes or so. You can start before we rise it. Okay. All right. I think we break now. We break now. Okay. The view is that we break now because it is about 8 minutes past 1.
Yes.
And then we need to start promptly at 1 hour after this time that we are joining. In the morning we had an unusual occurrence where council were late for quite some time. I think we need to manage our time appropriately. So we are now going to adjourn at 10 minutes past 1. I suggest we reconvene exactly at 10 minutes past 2.
I was going, my lord, to request your lordship to allow us a little bit longer time. This is lunch hour. We come at 2:30. If that is acceptable.
The lunch hour, we agreed and we were starting that it will be 1 hour.
Yeah.
So I respectfully suggest that we still take 1 hour because we have many parties to listen to. So let's come after 1 hour.
All right.
Fresh Fry Premium Cooking Oil now has a new look and an advanced spout and seal. Triple refined, zero cholesterol and natural vitamin E. Fresh Fry, always heart friendly. Now it's even more cooking friendly. Fresh Fry, the premium cooking oil for healthy living.
Celine and Margot grew up living opposite lives. Celine was raised poor in a remote area in the province of Cebu.
I want my baby back, please. This time I'm begging you to please give my daughter back to me.
While Margot had the life of